All right. Thank you for all your help here.
I'm sure.
Completely honest with you. I usually just not the one doing this. That's the thing. So tonight,
Obviously, neither are we.
yeah, tonight we're going to talk about these topics: the role of the land use commissions, individual land use commissions, actions by the commission, making the record, the Freedom of Information Act, affordable housing applications, recent cases, dealing with the press, and the new affordable housing law, HB 8002. With me tonight is Hiram Peck, a man of great experience and wisdom in this area. And Hiram, feel free to jump in on anything that I say, or you want to make comments or fill in the blanks. All right, let's see if we okay. First commission we're going to talk about is the zoning commission. And the role of the zoning commission is to enact, amend zoning regulations, zone changes, and act on special permit applications and site plans. And there are rules, separate rules to apply to each of those actions. But that is the universe of actions that a zoning commission can take. And zoning commissions are authorized by General Statutes 8-2 and 8-3. All of these land use commissions, with the exception of the Inland Wetlands Commission, are all found in Title 8 of the General Statutes. The Zoning Commission, the Planning Commission, and the Zoning Board of Appeals are all in Title 8. And the Zoning Commission is authorized under the Connecticut Zoning Enabling Act, which we will get to. The Zoning Commission acts in a legislative capacity regarding zoning regulations and zone changes. And there's two parts to that. One is the regulations, and the other is the zoning map. Whenever a zoning commission changes their regulations or changes their zoning map, they're acting in a legislative capacity, and we're going to talk about the significance of that in a few moments. And must take those actions in conformity with the comprehensive plan, little c, little p, not the plan of conservation and development, but the comprehensive plan. And the courts have said the comprehensive plan is the totality of regulations that come into play for land use in a community. And as I go along, if you have questions, just stop me and ask. We have a tendency to go too fast and go through this too fast. I don't want to do that. Now, when a zoning commission also acts in an administrative capacity, when it acts on site plans and special permits. Site plans and special permits. So it's an administrative action. A zoning commission may delegate special permit applications to planning or zoning board of appeals. It hasn't been done here, so we don't need to spend a lot of time. As of 2024, there was an update to 8-3 that each person newly appointed as a zoning enforcement officer had to be certified from the Connecticut Association of Zoning Enforcement Officials and maintain such certification for the duration of the person's employment. It's a relatively new act, so you cannot act in the capacity of a zoning enforcement official unless you have received that certification beginning January 1st, 2023. Now, 8-2 is that section of the Connecticut General Statutes that defines the actions and powers of the zoning commission. And it was recently rewritten in 2023. And the new version of that says what zoning regulations can include and what they shall not include. And as of the change, zoning regulations shall not prohibit the operation in the residential zone of any family child care home or group child care home located in a residence or require any special zoning permit or special zoning exception for such operation. That's a relatively new law that prohibits towns from writing regulations that limits residential family child care home or group child care home in a residence, or require special permit for such operation. In other words, those two uses have to be allowed as a right within any residential zone. Special permits approval requires that the proposed use be in accordance with the zoning regulations, and the standards and the regulations are satisfied, and the conditions established for that special permit are necessary for the public health, safety, convenience, and property values as established. Now, we have to distinguish between such special permit uses and site plans, which review of site plan is limited to determining whether a particular plan conforms to existing, I can't really see here, existing regulations under General Statutes 8-3G. So site plan determination, the role of the commission is really limited to whether or not the site plan as presented in the application conforms with the zoning regulations. Side yard setbacks, front yard setbacks, coverage ratios, all those dimensional requirements in the regulations. If a site plan application conforms with those, the commission has really no discretion but to approve that site plan. For special permits, the commission has a bit more discretion because there are special permit criteria. However, the Connecticut courts have become increasingly skeptical of special permit criteria that are overly subjective, using phrases like consistent with the character of the community. That's a very subjective standard. An objective standard would be, 4 parking spaces for a home above a certain square footage, or other criteria that can be quantified rather than simply left to the subjective judgment of the commission. If the site plan does not conform in a minor correctable manner, the commission may modify the plan and approve it. In other words, you don't have to say yes or no based on the plan that is presented to you. You can request that the applicant make minor modifications.
And that's true in the wetlands and ZBA as well, right?
Just talking about zoning.
Just
there are different rules for the commission.
Just to verify, you can get a copy of this presentation of the slides.
Oh, absolutely, absolutely.
Change
Yeah, don't bother making notes because I can send this to Carol's office and you can distribute it. And the commission is required by statute to record or transcribe the public hearings. You're usually going to record them. You're not going to transcribe them unless there's an appeal. And then when you have an appeal, you have to have that recording so we can transcribe it and create the record. Zoning Commission's DMV location of the use approval. PA 2340 says DMV location of use approvals have been moved from the ZBA to the zoning enforcement official. This is a minor change, I think. Anybody have questions on that? Anybody have questions?
You should have.
Sure. Any person who desires, you got it? Okay, so that's the zoning commission. Zoning commission, in a nutshell, adopts regulations, adopts a zone map showing the various zones within the community. Any change to the regulations or to the zone map is a legislative action. We're going to talk about why that's different. Zoning commissions also act on site plan applications and special permit applications, depending on how uses are classified within the regulations. An example of a site plan would be a residential use within a residential zone, typically as of right, site plan approval. If it meets the objective criteria, you've got to approve it. Example of a special permit would be different types of businesses in zones. Sometimes churches and houses of worship are permitted in residential zones by special permit. So under a special permit type of approval, you have, the zoning commission has more discretion, but it's not unlimited. Which brings us to the planning commission. The role of the planning commission is to adopt the plan of conservation and development, adopt and amend subdivision regulations, and act on subdivision regulations. And the third responsibility is to review plans for public improvements under General Statutes 8-24. Source of authority for the Planning Commission in Section 8-8 through 8-30A. Action regarding the plan of development and conservation and development and subdivision regulations are legislative. Actions on subdivision applications are administrative. And that's an important distinction because sometimes you'll get a subdivision application and, you know, 4-lot subdivision where the neighbors don't want it. And you'll have a room full of people saying this is going to destroy the universe if you approve this 4-lot subdivision, don't you dare approve it. Planning Commission has no discretion but to approve it if it meets the subdivision regulations. So it's important how you write those regulations. If you want to preserve certain discretion, you have to carefully build that into your subdivision regulations. Because if it's not there, you can't insert it based on what you may want to do with a particular application. It's an administrative approval. You may not disapprove a subdivision application on the basis of standards not contained in the existing subdivision regulations. And a subdivision application is considered and acted upon on the regulations in place at the time the application is filed. So you can't get a subdivision application in that you really don't like and say, oh, we got to change those regulations. Too late. Too late. The third land use body is the Zoning Board of Appeals. The role of the Zoning Board of Appeals is to protect the interest of individual property owners by granting variances and hearing zoning enforcement appeals. Variances and zoning enforcement appeals. That's the role. Now, the Zoning Board of Appeals acts in an administrative / quasi-judicial capacity regarding variance applications and zoning appeals. Every application before the ZBA requires 4 affirmative votes to approve. So you got 5 members ZBA, you need 4 out of 5 votes for an affirmative action. 3 of 5 votes, the action fails. So if you have a meeting and there's a variance application and only 4 of the 5 members are in attendance, the applicant has the right to say, I want to defer until all 5 people are here. I don't want to have to get a unanimous approval. Given that you have to have 4 of 5 votes, I'd rather come back when there's 5 votes, and you'd have to grant that continuance for that to allow that to happen. Any questions on the role of the Zoning Board of Appeals? Zoning Board of Appeals is the only land use agency that has the right to vary the application of the zoning regulations. And there was a very prominent case a few years back. What's the name of the case? Where the zoning regulations allowed the zoning commission to waive certain regulations.
That was person.
Yeah.
Had to do with the landscaping and service station, I believe.
Yeah, and they said, well, you don't need to put 5 trees within a 20-foot stretch. Given that there's a lot of trees, big trees behind it, you can only put in 4 trees. We'll waive one of the trees. I'm making that up. But that was, what's that? Monroe? Yeah. The court held that the zoning commission, only the zoning board of appeals had the right to vary the application of the zoning regulations to a particular site. The waivers, which are were very common in zoning regulations based on individual circumstances, were illegal. So the point here is only the zoning board of appeals can waive the application or vary the application of the zoning regulations to a particular site. Now, hardship standard is very strict in Connecticut. 2 criteria have to be met for a hardship to be found. 1 has no substantial effect on the comprehensive zoning plan. And 2, more importantly, adherence to the regulations would create an unusual hardship. That's a very high standard for the approval of a variance. It's usually said that there is no such thing as a sign variance for that reason. So if someone wants a bigger sign than the regulation allows, they go to ZBA. It's very difficult to approve a hardship for a sign. And the hardship has to arise out of the condition of the land itself and cannot be self-created. A good example of that is if you have a lot and the lot has a lot of shale and rock and there's only one place to put a structure because of that, and that one place encroaches upon a 10-foot side yard and you need a variance in order to put anything on that land, that condition arises from the land itself in that the applicant didn't put the rock there. That would be an unusual hardship. If, in other circumstances, if someone wants to put in a big deck and the best place for the deck encroaches upon the side yard by 3 feet of the 10 feet, and the variance requests the 3-foot variance in order to put the deck where the best place is to put it, it's probably not the definition of a hardship because that's self-created. You can make a smaller deck, you can put it where you really don't want it. There's all kinds of ways around that.
Would shifting some things to avoid wetlands fit in that rubric? Establishment?
Probably not. Probably not. Because you could probably build it without encroaching on the wetlands. It couldn't be as big as you want it, in the exact location you want it, and there's no absolute right to build something in a wetland area. So it gets tried a lot because I can't put it here because the wetlands are over there. Depends on what it is too. It's one of those sheds everybody likes to put in and they want to put in the back, and they don't want it in the middle of their yard. They want to put it in the corner, but that's wetlands, and say I don't want to put it in the wetlands. So I need a variance to put it in the rear yard, required rear yard. The right answer is, well, you don't have to put it in the required rear yard. You just have to put it where you really don't want it. So that probably wouldn't qualify technically for variance. So that's the Zoning Board of Appeals. Variances, very hard to prove legal hardships. And it's the applicant's burden to show the Zoning Board of Appeals. And an appeal of a wrongfully granted variance is very easy to win an appeal because the court's going to look at it and say, well, I don't care if nobody's showing up at the public hearing. I don't care if all your neighbors are in favor of it. It's technically not a hardship. And I'll overturn the variance. The 4th agency is the Inland Wetlands Agency, and their role is to adopt regulations to protect the wetlands or water courses, act on applications for a license or permit for any proposed regulated activities. 2 concepts here that are crucial. Regulated activity within a regulated area. And you may know the wetlands, there's the actual wetlands delineation, and then there's the upland review area, sometimes called the buffer area. They're both the regulated area. And how the commission gets to define that upland review area is really beyond the scope of this presentation, but it's the commission's given, the agency's given a lot of discretion in defining that upland review area. This agency acts legislatively when amending its regulations and acts administratively when reviewing the application for a regulated activity. Now, if the activity is outside of a regulated area, it's not a regulated activity. So if there's a wetland somewhere on the site, but the activity, you got to look at what the activity is. The activity is outside of the regulated area, either the wetland itself or the buffer zone, upland review area. It's not within the jurisdiction of the Inland Wetlands Commission.
So even if there's wetlands on the property and you want to do something on the property, if you're not encroaching on the wetlands, you wouldn't be going before inland wetlands.
That is correct. Now, the Wetlands Agency is responsible for defining its own jurisdiction. So sometimes you go to wetlands just to get determination that I don't have to go to wetlands. We've seen a lot of that, right?
Yeah, I think here, isn't the upland review area 150 feet here? Yeah, so it's pretty big.
Yeah.
You know, it would be entirely possible, Carol said, that you put something on a piece of property, but if it's within that upland review area.
It's got to go to wetlands. Even if it's de minimis, even if it's 10 feet into the review area, it's got to go to wetlands.
And does that include something that will have effect on the wetlands remotely?
That's really the question.
Like if you put in something that is going to sluice mud down into the wetlands or something.
Yeah, that's really why you need to go to wetlands and ask them whether or not they want to exercise jurisdiction. If you have to, if your activity is creating runoff that will in fact find its way into the wetlands, and you have to put riprap in the wetland area to disperse that runoff, that's a regulated activity.
That's kind of the thing I'm asking.
Yeah, the minute you displace any threshold amount of soil within regulated area, you got to go to wetlands to get that approved. And then there's a conservation commission. Conservation commission is not a regulatory body. Its role is to develop conservation, supervision, and regulation of natural resources, including water resources, and resources of soil authority is 7-131A. Most towns have a combined wetlands conservation, inland wetlands agency / conservation commission, so that the two functions are really very closely aligned. But it is a separate commission, and there may be conservation commission regulations or the statute that requires a conservation commission report on activity, and the scope of those reports are defined by the regulations.
Usually a developer will go to inland wetlands or go to conservation before they go to planning and zoning. Is that true?
Yeah, the zoning commission and the planning commission cannot act on an application that requires an inland permit prior to that permit being obtained. They can accept the application, they can hear the application, but they can't take action until the Wetlands Commission acts.
Right, so yeah, and so if they provide an application or put in an application that is going to involve in the wetlands, we can look at that again and request that they get that and then
Right.
hold it.
That's right. Now, the issue with that is you may run into your deadlines for action by the zoning commission.
Right, in which case we can ask them to withdraw the application and reapply.
That's right. Or to provide an extension. Lots of times applicants will want to, they're in a big hurry, they want to get everything approved, they'll apply everywhere all at the same time. There's some benefit to that because at least the zoning commission knows what's going on with the proposal before it has to act on it. But by statute cannot act until the Wetlands Commission acts. Conservation Commission specific powers, proposed greenway plans, take inventory of natural resources and formulate watershed management and drought management plans. Keep an index of all open areas. May recommend to the Planning Commission plans and programs for the development of such areas. And make recommendations to the Zoning Commission, Planning Commission, and Inland Wetlands Agency on proposed land use changes. In the ideal world, in your plan of conservation, your open space plan would find its origin from the Conservation Commission. It's really the way it's supposed to work. And the plan of conservation says, this is our open space plan. These areas are targeted, either preserved for open space, or we would like to target them for preservation of open space. And that, again, in an ideal world, should come from the Conservation Commission, which many times is the Inland Wetlands Commission. Any questions on the Conservation Commission? Sometimes it happens that the Inland Wetlands Agency spends so much time on inland wetlands regulations, the Conservation Commission function takes a back seat. Just like with combined planning and zoning committees, there's so much time spent on zoning, sometimes planning takes a back seat. So that's just to be aware that that happens, and try to plan so it doesn't happen. And here's some more specific powers of the Conservation Commission. With the approval of the legislative body, acquire land and easements and promulgate rules, supervise and manage municipally owned open space, keep records of the meetings, and receive gifts in the name of the municipality for any purposes, and administer the same. So the Conservation Commission powers under the statute are very broad. It really is the agency for the identification and management and potentially acquisition of open space. In my experience, there's lots of other town agencies that take the lead on that. The legislative body usually takes the lead on acquiring open space. Sometimes towns have open space committees. There's private land trusts. There's a lot of different entities that play a role in open space. But by statute, the Conservation Commission really should be a major part of all that. Actions by a commission, we talked about legislative and administrative action. We're going to talk about acting on an application, improper actions or participations by commission members. A legislative versus administrative action. The commission has a great deal of discretion in acting in a legislative capacity or than when performing administrative functions. Think about a state legislature or the Congress or even the Board of Selectmen. Those are legislative bodies that act legislatively, and the courts give great discretion when any body acts in legislative capacity. The idea behind that is when acting in a legislative capacity, the zoning commission or any legislative body is doing the will of the people who put them there, and courts are very reluctant to replace the court's judgment with those for the locally elected or appointed legislative body. So very, very high bar. Administrative functions, however, once those legislative actions have taken place, zoning regulations have been adopted, the zoning map has been approved. The idea is that the public, having read that zoning regulations, looked at the zoning map, and bought a piece of property with that in mind, the courts will hold that commission to the rules that it set up and allow the property owner to take advantage of those rules. Sort of a due process concept. I buy a lot in a residential zone and I want to build a house. The commission can't say, well, no, you can't build a house because we don't like the look of the house or whatever. I bought that knowing the rules. The rules can't change after the fact. It's really a due process issue. Legislative actions are generally upheld as long as within the statutory powers. If the commission takes a legislative action which is outside of its statutory powers, then all bets are off. They don't have power to do that. And again, I've said this many times, administrative functions are more restricted. Basic function in such situations determine whether the application conforms to existing regulations.
Statutory powers also means ordinances and regs, not just state statutes.
Yes, and I should have said, the zoning commission, all these commissions have no common law powers. The commission's only source of authority comes from the general statutes. There's no common law of land use in Connecticut or anywhere else. So the statutory powers really are the totality of authority for these commissions. You can't say, well, we did it 10 times in the past wrong, therefore we have a common law right to do it 11 times wrong. If it doesn't comply with the statutes, then the commission doesn't have the authority to do it.
If you change the zoning regulations, for example, what controls the time that you submit the site plan or the time when you bought the property originally?
The time you submit the site plan.
So if you buy a vacant lot and the town changes the regulations, you're stuck.
That is correct.
Including zoning, right?
Just be careful about that. There's a case in Wilton called the Warrior case, and that had to do with a lot that didn't meet the current zoning regulations, but it was not built on in any way before this particular person came in with the application.
Was that a subdivided lot?
Yeah.
Because the rules of subdivided lot are different. Because an approved but unimproved subdivision lot, in most cases, you're entitled to take the regulations in place at the time of approval of the subdivision with you when you buy the lot. That happens a lot. Make it a pun, but because there's a whole lot of subdivisions that are approved but unimproved. They're all over the place. There's thousands of lots in the state of Connecticut that are in approved subdivisions, but have not yet been built on. Approved but unimproved. Those rules are tricky, and they need to be scrutinized by town planners, town staff to determine what the property owner's rights are. I was referring more to a vacant piece of land that's not part of the subdivision. But yeah, Hiram is correct. The rules that apply to unimproved subdivisions are more complicated than that. Okay, general rules when acting on an application. Most applications require public hearings, publications of 2 notices. That does not apply to site plans. There's no public hearing requirement for site plan applications. There are public hearing requirements for special permit applications. There's no public hearing requirement for subdivisions. Our public hearing requires for re-subdivisions. Now, most subdivisions, the Planning and Zoning Commission schedules a public hearing. But technically speaking, it's not required. Proper notice is mandatory for an agency to have jurisdiction over an application. Proper legal notice is that notice that is required by statute, not by your regulations. The local regulations notice requirements are not jurisdictional. Where you put up the sign, that's not a statutory requirement. Where you publish a notice in the newspaper is a statutory requirement. If you don't meet the deadline days of those 2 notices, it's jurisdictional, meaning it deprives the commission of its jurisdiction. And in the past, there may have been occasions where you find out the day of the meeting, oh, the current didn't get the notice, the New Haven Register didn't get the notice in on time. You didn't meet the deadline. Can we still act? No, you cannot. You got to renotice that public hearing. You can act, but it's subject to being overturned by a court if somebody appeals. And that's not a 15-day matter, that's a 1-year matter. Because inadequate notice was a 1-year statute, not a 15-day statute. You could bring that claim within a year, not 15 days. Public hearings must be completed, generally must be completed with statutory time limit. Decisions must be rendered within the statutory time limit. If there's no public hearing, there's 65 days to act on an application.
Can an applicant waive the time limit
The applicant can extend the time limit.
for how long?
35 days, 60, but a bank of 65 days of extensions. And that 65 days can apply to any one of the three periods. The period between receiving the application and opening the public hearing, that's period one. Second period is when the public hearing is open. 45 days? 35 days? It's in here. 35 days. That's period two. Period three is once the public hearing closes, the commission must act. So that 65 days can apply to any one of those, but you can't, it's a bank. If you spend 20 days in the first period, you only got 45 days left. And the applicant has no authority to waive beyond that 65-day bank.
So what happens if you don't resolve this within 65 days?
Well, depends on what the application is. If it's a site plan application, it could be approved by the operation of law.
That is without a hearing or without a decision from the commission.
Right.
What if it's a special permit or something like that by law requires a hearing?
Then the automatic approval statute does not apply because of the public hearing requirement. Is that your understanding of that?
Yeah, I think you still, I would be really careful about missing those deadlines.
Yeah.
But it's an aggregate of 65 days. I just want to make that
It's like a
clear.
bank of 65 days, you can get, as Bob said, 20 days here, 20 days there. whatever.
Yeah.
The total maximum that the applicant has to give the commission is additional 65 days.
If you run out of time, your best course of action is to deny the application without prejudice
And has to resubmit.
and ask to resubmit and be generous about waiving the application fee if it's the commission's fault for not acting in time. And sometimes it happens, the snow days we've had, and there's all kinds of things that can happen. But the best course of action is to deny the application without prejudice and invite the applicant to resubmit and clearly express that in the minutes. The applicant has 15 days to appeal from zoning planning and zoning board of appeals journals. That's 15 days from the date of publication. Usually takes 5 or so days to get the notice of action in the newspaper. So from the night that the application was acted on to the end of that 15-day period is usually 20 calendar days.
A little tricky thing with that 15 days too, Bob, correct me if I'm wrong, but it's gotta be in the sheriff's hands by that time.
Yes.
The sheriff might be doing something else, it might
Yeah.
be in his house, whatever.
Yep.
As long as he's got it in his hands by that time.
That's right.
you can get it.
There's a statute, not in Title 8, but in Title 52, that says if I place the writ in the hands of the sheriff within that 15-day period, that tolls the 15 days, and he has X number of days to actually serve it. Service is easy. Service is on the town clerk. You don't have to go 100 different places. And most competent sheriffs know just how to do it. So, yes, that 15 days can be extended if it's shown, and the way you measure it is what it says in the marshal's return. Marshal's return. And they know how to do that. They would be very clear as to when they received it.
So the appeal is to the marshal?
The appeal, the marshal serves it.
Okay.
So if I place the complaint, the appeal, in the hands of the marshal on the 15th day, and the marshal takes 10 days to get it to the town clerk, that's still a timely appeal.
But my question was that if I wanted to appeal, I would have to find the marshal and hand him my appeal.
That is correct. Unless you as a pro se, even as a pro se, you don't have to serve by a marshal. Service of process is done by a marshal or indifferent person, or constable. which is an person.
That's why I hired an attorney, Steve.
Yeah, well, that and many other reasons. Yes. I'm speaking to other attorneys, I will point out.
Having said that, if you're a pro se and you're the neighbor to the approved out, and you really don't like this application, if you go down to Superior Court, the clerks are very good about walking you through all that. And they'll help you do it right. And again, it's not a difficult service. It's got to be in the hands of the town clerk. Lots of times, even marshals will not get that right. They'll serve the first selectman, they'll serve the clerk of the commission, and they won't serve the town clerk. It's fatal to the appeal. And usually, if you see that, you wait until it's more than 15 days, and then you bring it to their attention so they can't fix it. And here are those dates again: 65, 35, 65. 15 days to appeal. Okay, sure.
Until I get my select copy from Carol.
Yeah, I'm going to send it to Carol tonight.
That's important.
Yeah, that is important. It's, it takes a little work to keep track of it. Okay, improper actions or participation by commission members. Insufficient participation in an application to decide it fairly. The member must be sufficiently acquainted with issues, evidence, and arguments presented at the public hearing and the evidence before the agency so as to make an informed judgment. So if you have a member, if you have a multi-night public hearing, 3 nights it's called, and one of your members misses the second night, it does show up for the third night, public hearing closes, the member who missed the second night has to state on the record, I feel I am sufficiently acquainted with the issues, evidence, and arguments presented at the public hearing. I know I was missing the second night. However, I listened to the tape and became acquainted with the matter through listening to tape. If the member doesn't say that and votes on the application that he missed the night, it does create an appealable issue of whether that member was sufficiently acquainted. Now, it's harmless error if it's unanimous approval and one member missed one night. If it's not a unanimous approval and that member's vote made a difference between approval or denial, it could potentially be a valid issue on appeal. Sure.
Are there any, have there been any concerns with people trying to claim that, say, Zoom, if you're zoomed into a meeting or something like that, that doesn't count as being present?
There may be, but under FOI, you may participate electronically. So it's as if you're present in the room.
That's actually a good thing to have cleared up. Thank you.
Yeah,
Cool.
that's right.
Could you state that again?
The question, it was whether it would be a concern regarding the familiarity with the case and whether it would cause issues for appeal or anything if a board member was zoomed, like, electronically present during the meeting. And I guess because of FOI, you said it's not an issue because they are considered present.
Thank you.
Yeah, there's a specific section of FOI that says members of an agency may participate by electronic means.
Okay.
And then there's a separate COVID amendment to that, COVID-related amendment to that, which we don't need to get into. That's the one that allows for hybrid meetings.
So does sufficiently acquainted also mean going to do a site visit?
Yes,
Is that mandated?
the site visits are not mandated, but the rules of site visits are that a site visit is a commission meeting. And if a member can't be present at the commission meeting, that was the site visit, and the member would have to state that, yes, I missed the site visit. However, I made myself familiar with the property by independent means, such that I feel I'm sufficiently acquainted with the facts and circumstances.
So, and I have read this because I have that little guidebook that UConn publishes on this. If you go on a site visit with the full commission, how do you record that? Because it's
You shouldn't,
effectively
you
a
shouldn't be
meeting, right?
talking.
You should not be talking.
Right, we shouldn't be
You can't do
discussing.
any
Yes.
discussion.
And what I always recommend, you go out to the site, you can't have, usually you don't have a clerk with you with a recording device. So what I always recommend is you go out to the site and you say, where's, you could do that, but you know, where's that tree shown on the plan? Oh, it's over there. Where's that little brook? It's over there. Then you get back to the meeting. On the record, you state what the general contours of what you saw. You say, I asked the applicant the following question on the site visit, and this was the response I got, with the idea that everything that happened out in the field, you're putting into the record at your next meeting.
Generally, you shouldn't be talking to the applicant.
Well, if for factual matters, to say, all right, I'm familiar with the site plan, you know, where's that, you know, bluff that's on it? It can't be, you know, things of subjective nature. You can't be having a give and take. And the commission members, please don't talk to each other because you have to do that back at the meeting. You get back to the meeting and say, you know, I was at site visit and I saw this, this, and this, and here's the impression I had. That's got to be on the record.
Right, so take your own notes if you want, but you can't share them with anyone until we're on the
Until
record.
you're on the record. The idea
I can
is
talk to my commission members, like, don't stop there.
right.
Right, but I can't say,
Right.
wow, look at that.
Where are we having lunch after this? You can do that.
Right. Nothing that's pertinent to
Yeah,
the.
because again, it's a due process standard.
Mhm.
The reason you do it that way is because you have to give the applicant and the neighbors the opportunity to either rebut or at least be aware of what's on your mind as commission members when you're out there in the field. And if you're talking to each other in the car coming back from the site visit, like, oh, I don't know if this application is going to work, that's ex parte conversations that the applicant isn't aware of and can't rebut or comment on. You always have to think about fairness to the applicant and the fairness to the other people interested in the application.
So anything that's gonna be used in making your decision has to be on the record.
On the
for
record.
everyone to see.
That's right. See, hear, look at.
The important thing about sidewalks is that there's going to be a quorum driving notice.
Yes, absolutely.
So sometimes you can get away with just, you know, one or two people want to go. Maybe they happen to be the same political party, that's fine. But when you get a quorum on a sidewalk, it's got to be noticed.
Special meeting. Or you can go out by yourself, you know the town, that's why you're there on the commission. You can go and say, I know that property pretty well. You can't trespass,
I was just gonna point that out, yes.
but you can observe from the street.
Does the applicant have to let you on their property?
You know,
If you're an individual member going out, can you contact the property owner for access to your site?
yes, you can. And again, the proper way to do that is to, when you come back, put it on the record. I called the applicant. He was there on Saturday. He allowed me on the property. Here's what I observed.
Which make a comment about that. I would just be really careful when any commissioner is talking directly to the applicant.
Right.
Do it through staff,
Yeah, I think that's
you
right.
know, because then you can say, I just want to know if I can go there at 10 o'clock on Saturday. And have the staff get back to you and say, yeah, fine, go ahead. If you call the applicant directly, somebody's going to say, hey, wait a second, what's going on?
Ex parte conversation with a commission member.
You have to prove you didn't talk about something else. Would email be a way to do that, because it self-documents?
Yeah, I mean, today everybody does everything by email. As long as that email is put in the record at the next meeting.
Just
Again,
open it front through staff.
No,
I think
go
so,
through
yeah.
staff, have staff email, and
Maybe
then they
you
can
could go to the
print their
applicant's
emails.
door and ring the doorbell and say, as planned, just want you to know I'm walking your property. I can't talk to you about it. And then just.
Right, I think if you're gonna walk on someone's property, you need to let them know you're there.
right.
Even if you, I mean, not to ask permission when you show up, but you have permission set up, you're coming at 2, you show up at 2, you still knock on the door and say, I'm here, you know? You get shot.
Just because this is kind of ties to my job outside of all this, when regarding like individual sidewalks, is there obviously physically being there and putting eyes on is better than anything else. But is there any statute or possible case law involving issues if people have claimed to be familiar with the site, but they're only familiar with it through GIS or something like that?
I think again, if you state on the record that you made yourself familiar through GIS, publicly available GIS sites, best practice, make a copy of that picture, GIS picture, put it in the record so everyone knows what you're talking about. GIS is notoriously inaccurate.
Okay.
Can't confirm.
Yeah.
That's why I'm in business.
Yes. And shows things that aren't there anymore, or doesn't show things that are there now. Because you generally have no idea, and does not show the accurate location of property lines in most cases.
Mhm.
You can become generally familiar though with a site through GIS.
Because the reason I ask is sometimes, especially in Bethany where it's very wooded and we have such a low pavement percentage, LiDAR maps and things like that are very useful. And example, someone's trying to put something, but it's close to the wetlands. The wetlands are delineated by a stone wall. You can't see it through the trees, but like a LiDAR map would show where that stone wall is. So obviously that's still not as good as physically being there. I was just curious about the efficacy of using GIS, not necessarily as your only familiarity, but supplement.
Yeah, I think it's fine as long as that supplemental information finds its way into the record, because then that gives the applicant the opportunity to say, oh, that GIS was way wrong. You know, it was taken 10 years ago. Here's what it looks like now.
Again, they have to have the ability to rebut or the.
That's right. That's right. That's always the standard.
Can I ask, are there publicly available LiDAR mappings?
There should be all over the place. Yeah.
The
I'm not sure at the age of them, but they are. I know state's been doing drone flights and mapping. Specifically, the only study I'm familiar with is stone walls. They're mapping old stone walls as a basis of a conventional property line survey in certain areas, because the stone walls used to be the property line. So they're trying to find old markers, stone walls, things like that, to find 200-year-old property lines so they can then adapt from the rest of the public record and figure out where the other property lines are.
Deep has been very active doing that now. Very active. In fact, they just announced, a publicly available mapping site to help you with LiDAR related activity in the past month or so.
And aren't they doing tree canopy surveys as well? Yeah.
I'm not sure if it's started or how efficient it is, but I know there's things floating about that being done. I'm just not sure the status.
The next topic is improper action or participation by commission members. There's two topics here. One is predetermination, whether it's bias. Predetermination involves an issue whether the member was so close-minded that the mind was made up prior to the public hearing or hearing from the applicant. The presumption is that members are unbiased and act properly. Heavy burden on the claimant to prove that there was predetermination and bias. Very easy to allege, much harder to prove. Claimant can present evidence regarding the remarks made prior to the public hearing regarding the application, so-called ex parte remarks. And the admonition is to avoid such remarks. So everyone knows you're on the commission. You go to the grocery store or wherever, you run into the neighbor. The neighbor says, oh, I've been following that application pretty closely. That's the worst application I've ever seen in my life. It will destroy Bethany as we know it. And you say, you're telling me, boy, no way on God's green earth will I ever vote for that application. That obviously is the wrong thing to do, because that's predetermination. Or application comes in and it's across the street from your house and it's for a meat packing plant or something. It's going to be hard to show that you aren't predetermined to have a negative view of that application. the best way to approach that is if you get approached by your neighbors, and you all do, you get emails, you get text messages and stuff, you see things on Facebook, you should always say, we're very interested in your opinion on this application. The public hearing is next Tuesday. Please come down and share it at the public hearing. And say, well, you agree with me, this is terrible, right? But don't ever, or this is great, don't ever offer your opinion outside of the context of the public hearing.
I thought talk about your example if you're next door to the meat packing plant that's going in. Am I correct that you should either recuse yourself or go to the meeting and say, just want everybody to know on the record, I live next door to this applicant, or I'm cousins with the applicant, or
Yes.
I hate the applicant. I mean, at what point do you recuse yourself,
Sure,
and at what point do you just put it on the record?
Whenever there's a potential issue of predetermination or bias by virtue of where you live, who you're related to, relationship with the applicant, you name it, put it on the record and either recuse yourself or explain why you don't have to recuse yourself. And the closer the relationship between you and the applicant, the more there will be the appearance. And Connecticut law is the appearance. It's not the actual, the appearance of improper action. Very, very broad standard. There's a balance here because you all have, you're all private citizens, you serve on the commissions for no pay, you all have jobs, you know people, you're in different faith congregations, or in different clubs, whatever, you know people. That's one of the reasons you're here, is because you know the community. So you have to balance your knowledge of the community and your friendships with your role in the commission. If you're a bank officer at a local bank and the applicant is a customer of your bank, you have to ask yourself whether that business relationship will so cloud your judgment in favor of the applicant in this instance that you don't feel you can be unbiased. Then you got to recuse yourself. Another word on recusal. Recusal means you state on the record why you need to recuse yourself. What's your potential conflict of interest is. And then you don't sit in the front row and watch the commission while they act on it. You have to physically leave the room so that you can't be accused of directing your co-commission members through your facial expressions.
You have to leave the room. You can't sit in the room and be Joe Citizen.
No, you cannot.
You can't give your opinion as Joe Citizen?
No, you cannot. Because you're always a member of the commission. You don't lose that status by saying, hey, I recuse myself, and go up to the microphone and say, let me tell you why, fellow commission members, let me tell you why you're turning this down. That's not going to work.
Okay.
No, that makes sense, actually, and parliamentarily too.
Mm.
If you're supposed to not participate in the action of the committee of which you are the chair, you can't then approach it as just a random member because you're the chair.
You're the chair, and you don't lose that status.
Influence over that group, regardless of what space you're occupying when you're doing that. That makes perfect sense.
Yeah, that's the rule.
Yeah, your opinion will still sway theirs simply by association.
Now, it doesn't mean you can't follow it, because these are all live streamed and you can always watch the recordings too.
I think that's right. Yeah, you don't have to put blinders on. You can watch it. You just can't be in the room. You can't participate either through speaking or body language. And the reason you want to do that is you don't, first of all, it's not fair to the applicant or fair to the rest of the community who happen to be there. And you don't want to create appealable issues that will taint the commission action, whatever that commission action is. And there's also a larger issue of the credibility of the commission. People need to know that the commission gives fair hearing to everybody. Yep.
I have a follow-up question with self-recusal or putting yourself on the record as thinking you can be impartial.
Mm-hmm.
If, say, you as a board member don't necessarily believe that this other board member is being truthful about I can be impartial about this.
Mm-hmm.
What is the procedure about going on the record and saying respectfully, I don't think you can be impartial about this. If anything, it just goes on the record. I don't think you can force them out of it, but it puts it on the record, and that does make grounds for an appeal from the applicant or the appellant or whatever. Or it seems like it does.
Yeah, no, I hear what you're saying, and I think it's possible for you to actually ask for a vote of the full body.
Okay.
To
Sometimes,
ask the person to be
We
recused.
vote
Yeah.
on what? A
Yeah,
motion to
recuse it.
recuse?
Yes.
sometimes people get stubborn, and they
Yeah.
just don't think they should. And if it's,
There was a situation not too far from here,
You can vote
years
somebody
ago.
off.
for that matter,
Just for that matter.
The commission could vote as to whether somebody was disqualified or not disqualified. My understanding is that it's up to that person to decide, to make that decision.
yeah, I think that's right, but in the face of a vote to disqualify, if the person remains stubborn and says, well, thank you very much, but I'm not going anywhere, I suppose then they get to sit there. You call Marshall and physically.
I just, as chairman, I guess I would say, vice chairman, whatever, I would just say, anybody, and I've seen commissions do this, it's kind of interesting, does anybody have any conflict of interest with regard to this application before we start this thing?
Mhm.
I don't get all the way through it, get you all the time.
Yeah. The other interesting part of this is if the applicant or the applicant's attorney believes there's a conflict on the commission, they actually have to raise it and make it part of the record in order to use it as the basis of appeal, because the court's not going to put up with, well, you're sort of late in the weeds and you didn't call it to the attention of the commission. I've seen cases where that,
At what point would they raise it?
well, as soon as they know, they can't wait until the public hearing is going the way they want it and say, well, things are going well, and they have to raise it at the start.
Mr. Smith, I know that you worked for the applicant for a number of years, and we don't think you can be objective about this application. We request that you can recuse yourself from the application. I think putting something like that on the record.
Yeah, I think that's right. And I've been at hearings, you probably both have, where that's actually happened. And it's really uncomfortable because everybody kind of looks at each other like, what do we do now? You know,
I had a hearing once where the hearing was going on, and then it was the second day of the hearing, second week, and then the applicant brought in a witness, or really was a land developer person. I have no idea what they're called anymore. But you realize, oh my God, that's my cousin, or that's my friend, or that's my whatever. I didn't know you were going to be here. So there are times that you can say, whoa, I need to stop. I didn't know you were going to be here. Applicant has a right to have you here. But then the problem is calling in an alternate if the alternate wasn't on a previous.
but the alternate can listen to the tape
Sure.
of the previous one.
So you can backfill late,
Yeah.
as long as the hearing's still going on.
That's right.
An alternate just has to say on the record, I'm substituting in so that we have a quorum. I have listened or watched.
Made myself familiar with it
Yeah.
through listening to the
Yeah.
tape.
Yeah.
Rob, could you talk a little bit about caucusing? I don't really understand how that
Yeah.
works.
Caucus is defined in FOI of I don't want to say a meeting, a gathering of members of the same political party to discuss the political aspects and dimensions of a particular issue. And that second part is the most important part.
Issue, not necessarily a specific application.
Well, it could be an application.
But they have to address the political.
I don't know the exact language, but it's the political effect or dimensions. It has to relate back to
Party.
the party itself.
And political committee.
Same political affiliation.
Right.
Only members of the body, though, can be part of that caucus. You can't have the town chair come in and say, let me tell you, our party's opposed to it. The minute the town chair is there, It's no longer a caucus under FOI. And it's really difficult for me to understand how you're going to caucus over a pending land use application. I know people do, and I know it's probably legal. If you think about it, what are these people going to talk about other than how they're going to vote on the application?
So let me ask it the other way. Adam and I are different parties, but if we want to both go visit a property that's less than the quorum of our committee, that's not violating an open meeting rule, we can do it as long as we stick to the rules about not talking about it.
Unless you're going as delegates on behalf of your party. The FOI case is Susan Eat versus Tommy Starford. I happen to know a little bit about it. And I used to meet with the majority leader and minority leader of quorum. And the FOI commission said, you can't do that because they're there on behalf of their other members of their party. And I said, you can't, that's not, not a caucus. It's essentially an illegal meeting because the people that you're talking to are there on behalf of the party. So you just have to be careful. If you just happen to be from two different parties and you say, hey, let's go over next Saturday and take a look at it. Again, come back on the record and say, Joe and I went over and here's what we saw.
And you can meet with members who are not in your party in a caucus if the person is unaffiliated or a Green Party or Libertarian Party, and they ran as a member of your ticket. If they ran as a member of your ticket, they're part of your caucus.
I'm not sure about that.
Mostly
I'll
unaffiliated.
have to look at that.
But again, not to use you as an example too, but because we are different parties and we're not the majority of the group, but if I wanted to ask him, what did you think of that thing that the guy brought up? I can still do that, right? If it's a one-on-one conversation.
We don't have quorum. It's not
We
a
can't
caucus.
make a decision.
Is it just two individuals discussing something in town?
But you have
Just
the ability to act on the application.
Yeah, I would avoid it, to be honest with you.
Okay. I just want to see where the limits are. I mean, what if we did it and then reported it?
But you could go together, you could walk around together, you just
Just
can't
can't
talk
discuss
about
it.
it.
Yeah, I think that discussion should be on the record.
Yeah.
Fair enough.
If you have the discussion, you come
Just
back.
because I
to-
want to set the parameters to them, just, there's a lot of stuff that sometimes you need a finer and someone else's viewpoint on.
Yeah.
And why does that have to be someone in my party necessarily?
It doesn't.
It doesn't.
It
So do
doesn't.
it on the record.
There, as you're saying, members of the same body with a pending application, possibly an open public hearing, you've got to bring it back to the larger body because the rest of your commission members should have the benefit of your discussion.
Who always operated under, if there could be any question whether this is ex parte, don't do it.
Yeah, I think that's right. So,
Safe than sued.
yeah, these rules, conflict of interest rules, actually are found in the statutes, 8-11 for zoning and 8-21 for planning. A member may not participate in any decision in which he or she has a direct or indirect personal or financial interest. Indirect personal interest is a very broad standard. Personal interest is interest in the subject matter or relationship with a party that impairs impartiality. So it's someone that you have a very close personal relationship with, you vacation together, you blow together, or whatever.
Some kind of past financial.
Some kind of past financial relationship. You're a real estate broker, you've had listings, you name it. There's all kinds of personal interest that could create the appearance that it's impairing your impartiality. It's an appearance there. It's not
Also, a history of a significant ruin, I imagine, would be similar. You were talking about a personal relationship.
Yeah.
I was thinking that it's a positive relationship, but it could be a
It
negative.
could be a negative. You have animus towards this person because for whatever reason.
You screwed up your well or whatever.
Yeah. But at the same time, it can't be so attenuated that any potential run-in or personal relationship.
So a fist fight in fifth grade doesn't count.
No.
It's on Wednesday.
Nothing.
You want to tell us some things about yourself?
So Tate, there's no bright line rule.
There's no right.
You know, whether, you know, the parcel is 100 feet from your yard or 100 yards or 500 feet or 1,000 or, you know, in your neighborhood.
Yeah, that's right. That's right. There's no bright line rule. It's really, the test is whether the personal interest reasonably might conflict, whether the reasonable person would consider that to be so close that it could tend to appear to impair your impartiality. And then disqualified not only for the vote, but participating in hearing discussion matter. And you'd be surprised how many people recuse themselves and continue to sit at the dais and involve themselves in the discussion, but just don't vote. Not recusing. This is a tricky area.
Once you recuse yourself, can you change your mind and come back in?
No. No. You can't say, you know, I thought about it and I really don't hate that person as much as I used to. And no, once you recuse, you're out. You can't recuse yourself. Have the commission say, can we take a break? We should come over. Hey, we don't have a quorum. You just can't do it.
No, if you recuse and there's no quorum, you might as well just stop on that
Yeah.
issue. Just ask to delay it or ask for an
Yeah.
extension or something, because you can't, unless you can remedy the recusal at the time the decision is made. So if he recuses, say, and I don't have a quorum anymore, we can still hear it, and then I can bring in an alternate
That's right.
when I have one available and have them listen to the tape.
Or you can seat an alternate.
Right, if I don't happen to have one there, you know what I'm saying?
Yeah.
That pops me below quorum, I can still do it and then get someone to.
Yeah, you only lose a quorum when the member leaves the room. If they're still physically present, your quorum is not.
Yeah, but if they're recused,
They gotta leave the room.
right.
All right, improper actions or participation by commission members. I think we covered this quite a bit. Consideration of evidence after the close of the public hearing. This is a big one. The reason you can't do that is because the opposing party is entitled to rebut whatever evidence you're considering. And if you accept evidence after the close of the public hearing, in whatever form it's in, you got a bunch of emails after the public hearing closes, you got letters, you know, somebody called you up and told you, well, you one thing you didn't ask about, any of that. One of the reasons is that you can't consider it is because you have not given the opposing party the opportunity to rebut that evidence because the public hearing is closed. Several cases recognize exceptions where the agency obtains professional assistance from consultants such as engineers or attorneys. So your public hearing's closed. You see all kinds of information, big, thick reports on all kinds of traffic, drainage, all that stuff. You can ask your staff, hey, Hiram, what do you think of this? Give us your analysis of this traffic report. And whatever your staff report comes up with, as long as it's based on what's in the public hearing, it's okay. You can rely on your staff reports. If a proponent or opponent offers evidence after the close of a hearing, there is a rebuttable presumption of prejudice, and the action may be invalidated on appeal.
Well, that's if they offer it. That's if you use it, right? If they offer it and you refuse to accept it.
That's right.
Otherwise, that's a get out of jail free card.
Yeah. Now, it often happens the public hearing closes, you go home for the night, people watch it on the Zoom or whatever, and they start writing you letters or emails, sometimes directly to you at home. And what you need to do there is to bring them in the staff and say, this is not to be made part of the record, and don't consider it. Happens a lot, right, Hiram? Sometimes people don't want to hear it, that they came up with this evidence you absolutely have to consider. And they don't want to hear it, that the public hearing is closed and you can't make it part of the consideration. Those are the rules. This is just a practice tip. Always make motions in the affirmative. Your motion does not dictate how you will vote. Vote to approve that fails is a denial. Vote to denial that fails does not mean it's an approval or a denial. So sometimes it's hard to get the vote to approve because you hear an application and nobody wants to. So, and the chair says, "Can I have a motion?" Member says, "Hey, I vote to deny this." And if that motion fails, you didn't approve the application. The motion failed.
Right. So if you're chairing it, though, and someone says, "I move to deny," you could point it out and ask them to consider changing it to a motion to approve so that you can discuss
For
it.
purposes of discussion.
Right. And then you can all vote no.
You agree with that, Hiram?
I mean, that's general parliamentary rule.
Yeah.
Right? You tend to try to make motions to do something, not
Right.
to not do
Yeah.
something, and then you deny doing it, and therefore it is not done.
Right.
It keeps the record cleaner.
Yeah, because votes to deny that fail because people get confused. They say, "Well, I want to vote yes." Yes.
This is something that our board has actually run into a couple of times. We, example, motion to approve where the language isn't necessarily clear in the motion. It's possible to deny it based on the language and then make another motion to approve with the corrected language.
Yeah. Yeah.
Yeah,
Sometimes.
just withdraw the motion.
Well, I mean, yeah, you could also say it's not
It had
wrong.
already been said.
Oh, you could withdraw the
You
second
can
too.
still withdraw it.
Yeah, you can still withdraw it, but also you can simply say that you're not going to accept that because it's out of order because it's not clearly stated what the alternatives are or what the motion is intending. You can always ask for clarification of what the motion is intending. You don't have to accept it as business unless it's clear. Right? I want to do something. That's not a motion. I want to do this specific thing. That's a motion.
Yeah.
You can do a friendly amendment to change it.
So now we're moving into making the record, the all important record, content of the record on appeal and the standard of review on a traditional appeal. The record is what goes to the court for purposes of considering an appeal of your action. Land use appeals are record appeals, meaning whatever's in the record is what the court will look at, as opposed to de novo appeals, which is start over again. If it's not in the record, the court's not going to look at it and won't be part of the consideration of the appeal. So it's important to make sure that the record is complete. And it starts with the application, and it's all of the documents filed with the agencies, reports, letters, comments, whatever you took in for that application is part of it. Legal notices, copies of all maps, transcripts of public hearing and of the commission meetings. And the written decision should include reasons for the decision and any conditions imposed which airs air of legitimacy. If you talk about a condition, but you don't include it as a condition in your approval, it's not a condition that can be enforced. Like, well, I'd like to see that driveway 5 feet to the left. Yeah, that sounds fair. Yeah, that makes sense. You okay with that? Oh, sure, yeah. If you don't say motion to approve with the condition that they move the 5.
So all those conditions need to be stated with the motion.
Yes. To be enforceable.
That's what I thought.
Because the applicant can come back a year later and say, "I thought you moved the driveway." Turns out it wouldn't work, so we didn't do it. It's not a violation. You can't enforce it because it's not part of the approval. That's a simple example, but it doesn't get much more complicated. The standard of review of a traditional appeal, the court's function is to review the record made in the agency proceeding. Appealing parties are required to marshal evidence in the record to demonstrate that the evidence does not provide support for the agency's finding. Appealing party has the burden of demonstrating that the board acted imprudently, which is their role. The question is not whether the court would have reached the same conclusion, but whether there's evidence in the record that supports the decision reached. And the court, in a regular appeal, the court's duty is to search the record for evidence that supports the decision. And the decisions have said, look, these are volunteer bodies. They're not made up of our lawyers. We're not going to hold them to a strict code of evidence or formality. If it's in the record, if it's obvious that the action is reflected by the discussion. Now, having said that, if you have an application that nobody seems too worried about or concerned with, it still is a good idea to canvass the commission and put in the record why you're voting the way you're voting. Rather than just kind of looking at each other, shrugging and saying, and make a complete record that reflects the decision-making process of the commission. Helps a lot. You got to write a brief supporting the action of the commission, because you can say, on page 50, there's 13 pages of deliberation, instead of on page 50, they all said yes.
I also think it's important for when you're holding the hearing, all these hearings, when someone brings in a document, I mean, just have a plain piece of paper and make it document 1 or appellant's, applicant's document A or B or C or whatever, and just make a list of what they were. And the documents can actually be done beforehand by what's already presented by the zoning enforcement officer and the wetlands officer, and you can add to it, or you can just start one during the hearing. But I've seen in many of these hearings lately, someone will come up and say, I have this letter, or I have a map. Okay, thanks. You take it, and I think it really helps if you say, map presented by applicant. All right, this is now marked as number, whatever number that is. And you can put it in the right-hand corner, the left-hand corner, or the top, or wherever you're going to do it each time. But that way you know exactly what you've received, and it's also easy to find if the public comes in, if you need it for appeal, anything like that.
It makes defending appeals so much easier when the documents and the record is organized up front. If you have to figure it out later, it gets very confusing. Okay, the judicial review of legislative actions. When we talk about legislative action, standard is the decision reasonably supported by the record. If the agency has stated reasons, court determines whether reasons are reasonably supported in the record and whether they are pertinent to the considerations which the authority is required to apply. Basically, is it within the jurisdiction? Decision is upheld even if one of the stated reasons is sufficient to support it. If you gave 12 reasons why you're changing the zoning regulations on a particular issue, and 11 of them are completely out of left field, but one of them is valid, that's enough. If the agency has not stated reasons, the court searches the record to determine whether there's adequate basis for the agency's decision.
So then it sounds like it's much easier, at least for the court, to state your reasons succinctly when you.
Absolutely. Judges are busy people, and they've got a lot of these appeals. The easier you make the judge's work, the more likely the judge is going to decide in your favor. That's kind of a basic rule of all litigation. Make a judge work hard, you're putting yourself at risk. Judicial review of administrative actions. Finding will be invalidated only if not supported by substantial evidence in the record. Evidence is sufficient to sustain the agency finding if it affords a substantial basis of fact from which that fact and issue can be reasonably inferred. Again, administrative actions, not affordable housing appeals, which should have separate rules. The court is going to be very reluctant to overturn your decision by substituting the court's judgment for your judgment. The court's going to be very likely to overturn your appeal if procedurally you did something that violates the statutory procedural requirements. That's why it's always so important to follow the procedures as best you can, leaving the court with nothing to look at but your substantive judgments. Okay, the Freedom of Information Act. The overarching policy, FOI, favors open conduct of government and free public access to government records. Freedom of Information Act is involved in two things and only two things. One is documents, the other is meetings. And documents are divided into documents that are publicly available and documents that are exempt from public disclosure. And unless there is a specific exemption from public disclosure in the Freedom of Information Act, that document is available to the public. And there's like 22 exemptions.
What are they like? I mean, what sort of exemptions, just generally?
Well, one of the exemptions is for a document that's covered by attorney-client privilege. Another exemption is juvenile records of juvenile. Another exemption is, this one has a lot of litigation around it, is the business records, confidential business records.
Corporate secrets.
Yeah. And each of these exemptions has their own particular requirements to it.
So I don't need an exhaustive list, it's sort of general idea.
Yeah. But if it's not on that list, it's a public document.
And I know that all going to the training on March 19th for the FOI meetings.
Now, it says,
coming.
the very first sentence of that section says, unless otherwise not available to the public by law, the following documents shall be made. So what's that law? Federal law, HIPAA, FERPA, another federal law about student records. So there's federal superseding laws that protect the disclosure or exempt documents from exposure. A lot of people forget that little sentence is there. So it's got to be a fairly exhaustive analysis of what is and is not a public document.
Yeah, but to be fair, the overlap of HIPAA and land use is probably fairly small.
That's right. That's right.
I mean, national security concerns also qualify for that.
Security records, yeah.
Our overlap should and speak nothing.
Yeah, there's not.
Missile silos in Bethany.
Yeah.
Those are the safe
Non-existent.
houses that we're approving, yeah.
All those old Nike sites.
That's right.
That's right.
But the business record exemptions could apply to land use because sometimes in an application you receive those. And meetings, very simple. All gatherings of a majority or quorum of a public agency, except single member agencies, are subject to the meeting requirements unless they fall into the exemptions, which is non-meetings, such as collective bargaining, social gatherings not intended for discussion in public, chance meetings, executive sessions, for which there are 6 reasons to have an executive session, and you can't make a 7th. Like, oh, this is really, we don't want to talk about this in public. It's embarrassing. This and so on. So public meetings, subcommittees are subject to the meeting requirements, which are really, really simple. You got to post your agenda no less than 24 hours before the start of the meeting. Your regular meetings, they're 48 if it's hybrid. Regular meetings are posted in the beginning of your year with the town clerk. Anything that's not on that list of regular meetings is by definition a special meeting. Major distinction is you can add things to your regular meeting agenda. You cannot add things to your special meeting agenda once it's published. And then there's emergency meetings. A pipe broke and is putting pollutants into the river, and we got to stop it now. We got, you know what an emergency is, and you can't fake it. You can't say, well, we're calling that an emergency just so we can have a meeting and we'll do the notice. That's not how it works.
Car goes through the building.
But yeah,
When a car goes through your building, like happened down the street.
yeah, there are instances when you have to have an emergency meeting. Happened quite a bit during COVID. And here's the way, I just said all meetings except must be open to the public and properly noticed. Meeting does not include social meetings neither planned or intended for the purpose of discussing agency business. Permissible subjects of executive sessions do not include discussion on land use matters and most other matters that come before land use agents. Very,
Otherwise, if you're at a social gathering and you run into someone else on your board, probably best to just avoid business before that.
yeah, yeah. But we're all human, and the thing that we have in common is business, but it is best to avoid it.
Do you have a lot of things? If you said most purchases or gifts of property go before conservation, that could be done in an executive session. You would have to do
It
the executive
depends,
session
it depends.
initially.
Land acquisition
Yeah.
without more is not a valid subject of executive session. The rule is if by making it public, it would tend to increase the acquisition price.
If you're in the middle of negotiations.
Right, if you need to meet on an acquisition of land and you need to convince your other members of your agency that this is land you really, really want, and the seller or the donor catches wind of that and they change the terms of the deal, then you can have an executive session. Now, single member agencies like First Selectmen, these rules don't apply. Carol can have any meeting she wants. She doesn't post notices of her meetings. Where it gets tricky is if Carol wants to meet with members of a multi-member agency, you have to be careful to make sure it's noticed properly that it is a meeting of the First Selectmen, not a member agency.
That's only if she wants to meet with multiple members at the same time. Right?
Yeah, that's right.
If she does it sequentially, that's not a problem.
That's right. Now, the statutory requirements of your meetings, you may only discuss and act on an application at a regularly scheduled meeting or properly called special meeting. A lot of this we've already talked about. 24 hours in advance, affirmative vote, 2/3 to add additional business to an agenda of a regular meeting. And the meeting may be moved to fully online within 48 hours notice. Does not mean it can be automatically switched to an online meeting. You can't switch it to a hybrid meeting if you're within that 48 hours.
You can or cannot.
That gets tricky, especially like this winter when we've had these snowstorms and you still want to have a meeting, but you want to convert it to hybrid. I just had this last week. I said, it's too late. You can't do it. You're 30 hours from the meeting and you can't make it hybrid.
Well, I mean, that one big snowstorm where you got like 2 feet. Well, it's the last 2 big snowstorms.
Yeah.
That was there was enough notice ahead of time. You could have easily just said 48 hours ahead of time. Look, because it's likely to be bad, let's just make it a Zoom meeting.
You can do that ahead of time. It's just,
You can also meet, can't you, and not take a vote, it won't count. I mean,
well, the workaround that I suggested was, look, if you can get you have to have a location of the meeting, right? If you can get anybody, police, public works, to open up town hall, and one person can be in town hall, everybody else can be electronic, and you still have an in-person meeting, and you don't have to renotice it. You can if you want, but and this particular meeting was important because it had a deadline. And I said, well, in fact, we had to renotice the public hearing, which was happening tonight because we couldn't have it last week. And I said, we'll meet in town hall, convene a meeting, and then let everyone know that you're continuing the public hearing because you don't want to bring people out in the snowstorm. But you can't convert it to hybrid.
Or if you don't have a quorum, you just say we don't.
Right.
We're opening, we don't have a quorum, we're continuing until our next one.
Yeah, that's right.
Wait, just to clarify, you're saying we can't convert it to hybrid, meaning we can't convert it to fully online? where you can't?
Unless you originally noticed it within 48 hours, you can notice it as fully online. But this particular meeting
No, I
notice
see it.
said, well, we may make it online if the snow is bad.
I see.
It did not go to it.
Can I just ask a question about the agenda?
Sure.
Is that the town clerk's responsibility for posting meeting agendas?
Yeah, the town clerk does post it.
Yeah.
It has to get to the town clerk within the requisite period of time.
Right, you file it with the town clerk, and then the town clerk posts it on the board.
Right.
It normally happens.
And it's posted on our website,
Yeah,
but it's posted on our board. That's what, and he literally walks across the hall and posts it as soon as he gets it. But if it's within 47 hours and it's hybrid meeting, it can't be. You could still have an in-person meeting, but you can't be hybrid.
you can have an in-person meeting, and every member of the agency can participate electronically at your in-person meeting. This is where it gets a little tricky.
Well, because technically, if you have audio visual, it can be argued you were there.
Yeah, right.
Wait a minute, how are you differentiating between hybrid and one person, in person, and all the rest of the people remote?
Yeah, I was wondering that too.
In a hybrid meeting, that you've noticed to be a hybrid meeting, the difference is the members of the agency can attend electronically. It's the public that is the differentiator here. You can put it on your website and Zoom and advertise it's going to be Zoom, but it's still an in-person meeting. But if you have a hybrid meeting, then the public can participate by electronic means. Participation by the public or the microphone. If it's an in-person meeting, technically they can't participate because they're just listening to it because it's like this meeting, it's on the website. And I actually had this case before the FOI. It's very complicated because you think, well, we did tell everybody they can Zoom into it, but we didn't let them speak because it's an in-person meeting. If it's a hybrid meeting, it's like they're sitting in the room. And it's complicated, and the FOI change they made is not crystal clear. But so what I recommend is notice everything as a hybrid meeting. And you can make it in person, but you can have the aspects of a hybrid meeting, so long as you post that notice within 48 hours.
What about meetings in which there is not planned public participation? For instance, if we have a meeting of P and Z and there is no public hearing, there is no public participation,
Mhm.
everybody to come and watch,
Right,
which they can do by Zoom.
right.
So if I make that a hybrid meeting, it still doesn't.
Doesn't change the rules of land use is different because it doesn't change the rules of whether you participate or not. You can just watch in a hybrid meeting just like you can with an in-person meeting. So
So a hybrid meeting in that sense to the public would imply that they could come into town hall to listen instead of just from home.
yeah, that's right.
And on a land use meeting, unless you have a public hearing, the public's doesn't have the right to participate.
Right, that's what I was clarifying.
So a hybrid land use meeting with a public hearing,
They can
they can
participate.
participate.
Mhm.
An in-person meeting with a public hearing, they can watch it, but they can't participate unless they come down. So,
Which is confusing because members can be considered present through Zoom.
that's right.
Right. Right.
That's
So
what's
it's because of the difference in responsibilities. And right. So a public meeting that is just a public meeting. The board can be there in spirit, but the public to participate has to be there in person.
That's right.
It's specified hybrid.
Mhm.
Exactly.
It's a new world. It really is.
I mean, it's really, it's not that complicated. It just depends. So if they have a right to speak and you make it hybrid, then they can speak from Zoom. If they don't have a right to speak, it really doesn't matter.
Doesn't matter.
Yeah, if a public hearing is closed, they're still willing to be present or listen, but regardless, if there is no public hearing, the public has no input.
Mhm.
Which is a point that's hard to get across sometimes.
They do not like that.
Yeah. Well, how come so-and-so on the commission was able to participate electronically. I can as a member of the public. I mean, I had that before.
As you just said in your question, sir.
Next topic is affordable housing applications, statutory provisions, recognized grounds for denial, and affordable housing appeals. This is somewhat of a moving target. Let's go through it. Affordable housing development is a statutory definition. It's not housing that people can afford. It's housing that meets this definition, which is another thing that the public really struggles with, and rightfully so. It's assisted housing, or in which not less than 25% of the dwelling units will be conveyed by deeds containing covenants or restrictions which shall require that such dwelling be sold at or rented at or below prices which will preserve the unit's affordable housing as defined at 8-39A for persons and families whose income is less than or equal to 80% of the area median income, or 80% of the state median income, whichever is less, for at least 30 years after the initial occupation of the proposed development.
It's a mouthful.
That's a mouthful.
But it's interesting because it's local. It's 80% of our median income.
Yeah, area median income.
Or state median.
Or state if it's lower.
Whichever
Yes.
is,
So if you're in Greenwich, that 80% is the state median.
Yeah.
Okay.
And the New Haven SMSA would apply here, and the Hartford SMSA will apply basically.
What's area been interpreted as town or county? Or?
SMSA, Standard Metropolitan Statistical Area.
So that's the area that they refer to.
Yeah, a group of local towns that the federal government has designated as a standard metropolitan statistical area.
And what is the definition of assisted housing?
Yeah, it's
It could be like, it could be state funding, it could be like a project-based subsidy from HUD.
that's right. That's right. If there's a contract in place for a state or federal agency that by contract requires these same covenants be in place for at least 30 years.
It's subsidized financially.
Right. No, I
Yeah.
assumed that there was a legal definition
Yeah.
of what assisted housing is. And I just wanted to get some idea of exactly how.
Well, here it is. Assisted housing is housing that is receiving or will receive financial assistance under any governmental program for the construction or substantial rehabilitation of low and moderate income housing and any housing occupied by persons receiving federal rental assistance.
Okay.
It
You were just letting me think
is
about it.
leading up to it.
Yes, exactly.
Affordable housing, I just read that. So there's two requirements, two criteria that have to be met. The housing has to be has to meet the sale criteria, which we just read, and then the income criteria of the person buying the house has to. You have to qualify both by the sale of the property and by the income in order to satisfy. And you probably read in the paper that the new developments up at stores around Yukon, which were required to have these criteria, the developers having trouble finding anybody that is can
fit the criteria.
the criteria is because up there, a lot of people don't meet the income criteria. Any person whose affordable housing application is denied or is approved with restrictions on substantial adverse impact may appeal such decision under the procedures of 8-30G. We've heard a lot about 8-30G over the last few years and how it works and how it doesn't work. So how do you deny a 8-30G application, which essentially is an application that essentially does not need to meet the criteria of the zoning regulations in most respects. So the denial must be necessary to protect the substantial public interest in health, safety, or other matters which the agency may legally consider And those interests clearly outweigh the need for affordable housing. So that's the balancing act. And that the public interest cannot be protected by reasonable changes. And the agency must identify those specific public interests that it seeks to protect with denial. And the agency must state its reasons on the record, and that statement must take a formal, official, collective statement of reasons for its actions. So in an 8-30 application, it's a good idea to have staff prepare the resolution, and because there's a lot of work to it. I mean, it's got to follow all this, and Hiram can't come to you with one resolution for denial. He's got to put together two, one to approve, one to deny, because Hiram can't make that decision for you.
The one that we denied, there was one that we denied in town, only one was upheld by the court. The decision was 10 pages, and we were very careful.
Is
it?
Yeah.
We were upheld.
What was the basis of the denial?
It was sightlines,
Certainly.
safety, possibly using the same road for the child support and safety.
It takes something like that to support a denial of an 8-30G application.
Or infrastructure can be used as well.
That gets tricky, because if you say it's going to take the road from a Class C intersection to a Class D intersection, I don't think that's enough.
More
Like septic and.
more
water.
utilities.
Utilities, septic maybe, sewer capacity. I've had one in Simsbury. Yeah, 100 cottages, where the particular 4-acre parcel, which they proposed 19 houses, dwelling units, it greatly exceeded the assigned sewer capacity for that lot. But the court said, well, it may have exceeded the capacity, assigned capacity for the lot, but you weren't able to show that it was going to exceed the capacity of the plant.
Water, especially in this area, water is
Water could be. Yep.
We don't have the MDC with 12-inch mains everywhere.
Mm-hmm.
So if it stands to reason that if the depression cone in a well is big enough from the assigned usage of this proposed building, it's going to dry up the neighbors' wells. They can't just say, too bad, make the neighbors dig deeper.
That's the sort of evidence that the agency has to marshal. It's not the applicant's burden, it's the agency's burden to marshal that evidence to support the denial if the commission chooses to deny.
Mm-hmm.
So, and you can't just say that's going to happen. You're going to need some sort of expert report, because saying it is not going to be enough for the commission.
Like have a hydrologist.
A hydrologist. In your case, how did you prove that? Did you have a report? Yeah. And if your evidence to support a denial is 35 people showed up and really didn't like this, that's not evidence that's going to support a denial. It's going to be expert evidence on a major issue of public health and safety. It can't be aesthetics, it can't be not consistent with the neighborhood, not consistent with the community character, forget it.
It has to be safety or environmental.
Substantial safety that clearly outweighs.
Well, I mean, I think the example you give is a likely one here, and also pretty compelling. You can't force people who've already built their houses and their wells to
That's right.
Go dry and dig another 1,000 feet.
Yeah, that's right.
A lot of the wells, at least in the area where we've got so much trap rock, the wells don't necessarily need to be very deep. So these smaller houses that are going to have a reasonably small depression cone, you put a giant development in the middle of them, that development suddenly has a depression cone 5 times as wide as the other wells expected. Then all of a sudden they have to put tens of thousands of dollars into it.
No, I get it.
Yeah, it's
That's the type of evidence that you have to prove, and it's your job, agency's burden to
There's
prove.
a small drain on a small aquifer, it's not going to cause a big problem, but a big drain on a small aquifer.
Like, we don't need to worry about sewer, but if they're trying to put something big in an area where, say, the usage requires a 15-inch gravity main and you only have an 8-inch main in that area, you can't just make the town and the taxpayers pay to upgrade this entire area, because then you have to go even further downstream and further downstream to make the sewer that much bigger. So that's a massive hardship.
And with the septics, which is what mostly we have.
That
again is dependent lot by lot. Right? It depends on what you can get in the architects on the lot. And where you're trying to locate it. So that's really more site specific.
This was one of the reasons that CT 169 was arguing against like the mandatory affordable housing units, because towns like this or towns in the area we've had is a good example where, yes, there is sewer, but the sewer is in such an area, it's not feasible to put affordable housing in a sewer area, and you can't force people that have viable septic land to convert to sewer.
So if you have criteria that a 8-30G in your criteria and your regulations that an 8-30G application doesn't meet, those criteria have to be based on something more than just your subjective definition of that criteria. It has to be based on the objective need for that criteria. Such as, we need wells to be a certain distance because of the nature of the aquifer. It's that objective need rather than the subjective, we just like it that way, if that makes any sense. And of course, the agency bears the burden of supporting its motion to deny.
Those soft reasons were precisely why 830G was enacted.
What?
The soft reasons were precisely why 830G was enacted.
Yeah, to overcome what some perceive to be, barriers to the building of affordable housing through the exercise of the zoning, the power of zoning. The denial of application is upheld if any one of the reasons stated by the zoning agency is supported by sufficient evidence in the record.
So this would be, so when Carol and I were going door to door, we heard that Bethany Farms, there's a number of houses in that neighborhood, their wells went dry. So this is an issue that should be considered no matter what the development is.
Yes,
right?
You don't need an 830G to consider that
No, it
issue.
doesn't have to be affordable housing.
Yeah.
It doesn't have to be, it
No,
could be
no.
large houses on large lots.
Yes, but it depends on the sequence of the depression curve. So the size of the draw in a much larger development will be much, much larger than the size of even just a large house.
And that's determined by number of bedrooms?
It's determined by number of
Basically.
bedrooms. So you could have a 6-bedroom mansion versus 3 houses with 2 bedrooms each. So you have to think about,
The density again, how much water are you drawing out of a given region? Right, yeah, in aggregate. And the problem, I think, with Bethany Farms was that they just considered each house individually and not everybody on that street drawing out of that same aquifer. Because it's that one street where they're having. Because I knocked on those doors too.
Yeah,
And it's a real problem.
it's a real
There's
problem.
nothing worse than any problem.
Especially since like you moved in, you thought you're fine.
Yeah.
It's like another house goes in, or development goes in across the valley, and now all of a sudden no water.
So does a homeowner have any right to sue the developer or the town?
I don't think they have a right to sue the town.
No. But the developer who may not have.
I ran out of power. Show's over. We ran out of power. Is there a plug?
Does anybody online have any questions?
Did you run out of power?
We ran out of power.
We can plug it in.
Really need a cord.
Yeah, they're underneath here. There's a
No, he needs a cord to go use. Oh, he has.
Yes.
So we can find, whoa.
If you have transformer, isn't there? There's a bunch of cables right here.
There's plugs on the plug part's easy.
We have some
We don't have too much left anyway.
crappy young person who didn't hear anything to do. Excuse me. Sorry.
There's the plug. There's the plug part. There's the plug in right
There
there.
you go, thank you. Yeah, that's,
Is there any plug left there?
yeah, I'm looking to see.
Just shake one out, Steve. See which one's live.
Okay, so I'm not sure where each of these things goes.
We don't need them right now.
Well, it depends. I do want to pull up the hourly and the recycling.
All right, let's go, good run.
Tonight, any questions? I don't think
Just
there's.
utilize the one.
There are only two plugs here. One goes to.
Yeah, I wouldn't pull it out.
Right. You're gonna have to pull there.
We should talk to the first selectman about getting an extension cord. We're gonna be. Sorry, I didn't touch anything down there. Thanks, I'm sorry. It's like in a black box, in a hole, where there's no word.
You know we're in trouble finding a tech guy. Whoops, I'm sorry.
All right.
I didn't touch anything.
You leave for money.
Steve just started yanking things out of the wall.
Anything, it just, I was trying to see, I was trying to trace.
I was waiting. Does anybody have questions or anything that wasn't brought up?
Our owl woke up.
March 19th, there's a training at 3 o'clock and again at 6 o'clock for all of you, and about 70 other people it's the officers meeting. The gentleman who runs FOI is coming.
Yeah, he's good. I can
He's
zoom
good?
that, right?
Huh? You can zoom it.
Yeah, well, it'd be in Boston, so I'm zooming it, I'm missing it.
I think you can zoom it. We're gonna record it.
And I'll be off at the whim of the Navy again,
I
so.
think you can zoom it and we're gonna record it. So you should,
Okay.
it'll be on the next day anyway. But I think the town employees are gonna go at 3, but anybody could go at 3. And the thought was, and I could be dead wrong because he may do this differently, was a lot of the town employees deal with FOI requests for records. And, we need to know exactly what it is we have to turn over and how to turn it over. And so I think at 3 o'clock, he's gonna talk a little bit more about that, but it's also gonna talk about meetings. And then at 6 o'clock, he's gonna talk about meetings, because that's when most of the people who are coming in, that's what most of you guys deal with, but he'll also talk about records, unless I'm dead wrong and he's just gonna talk about everything on both, but that was my understanding. But once a year, we have a town officers meeting and you're all town officers, so you're welcome and required to come. Oh, joy, yes, come on. That's
It's
fine.
compulsory.
No fun about the little.
You didn't get you didn't get the invite to it?
Yes, but it was kind of conflicting information
Oh.
that I got from, she said,
We
she thought it was just for the chairman. She didn't.
No, it's for all town officers. I don't know if it's by statute or by ordinance, but we have a town officers meeting. We're supposed to once a year. Oh, no, please come. It's really interesting stuff, actually.
Join you for
But-
my.
March
we
19th.
can Zoom?
Yes, well, in theory. It's gonna be held in the gym
Okay.
because we think there'll be a lot of people. So we have a whole new system and we'll do our best to make it work.
And this is called what now? Officers meeting?
It's a town officers meeting
Thank
and
you.
it's on March 19th,
Thank
both
you.
at 3 o'clock and at 6. And it's going to be the head of Freedom of Information Commission
Thank you.
himself is gonna come,
All
yeah.
right. And it's worth knowing if you FOIA request ever lands on your desk. So,
We get so many of them. It is remarkable. Especially lately, we've gotten more and more.
The rule in Hawaii is you have to turn over documents you have. You don't have to create a document someone thinks you should have. And that's, a lot of them end up being that.
But what's important for all of you guys I don't know if this is true for every commission, every land use commission, Bob, you'll know, but you have to do 4 hours of training. I know at least for P and Z. I don't know if that's true for
It is.
for everybody.
I
So
think it's any land use.
Kurt, probably at the next time you see him at a meeting, they're on my desk. I could try and find them. But he drafted a form so that you could keep track, or he could keep track for you guys. If you fill in today, will be a couple of hours,
Yeah.
and this will count towards your training.
You need 2 more.
You need 2 more.
And you self-document. So if you spent an hour online watching a land use thing, and there's a bunch online for free, I sent a list to the planning and zoning members. I can send it to you. Your chair of inland wetlands, you said?
I'm ZBA.
ZBA and inland wetlands.
I'm vice chair.
It's Chris Sullivan, but if you send it to me, we can get him in.
I'll send it to you. And
Let me,
Just forward it.
this one, as it was recorded, it'll be a matter of public record that we were here.
Right, and the FOI thing will be recorded in that, and if you go to that, that'll be your time. And
no, the list I'm sending is the list of the free land use seminars that you can get. Some other towns have them online that you can watch. Yukon has some, and the Bar Association has some, but you have to pay for those.
Oh,
Yeah, the Yukon stuff.
here we go.
and we are gonna get,
Back. And we didn't lose anybody. That's impressive.
are you guys still there?
What am I now?
I'll assume yes.
That's just, yeah.
Where's the camera?
At
It's right there in that.
Hiram's suggestion, we're gonna get Bar Association books just on land use
Land use law.
law, and we'll have a couple of them. And you can take them, read them. We'll have one down in the office, probably in the land use office, probably one in the town clerk's office, just really so that you have access to whatever you might need.
Anything that, why, in my opinion, is you need to respond to whoever asks for within 4 days. It doesn't mean you have to have all the documents within 4 days, but you have to say, okay, I have your request. It's gonna take me a while to put this together, but you need to get that response back to them within 4 days. Yeah, we call it the 4-day letter. It's really a form letter. We receive a request and we will respond within a reasonable time. That's the statutory phrase, within a reasonable time. That's pretty impressive if you can do that. None of the big cities do that. What get you a letter back in 4 days? Well, you could make their lives miserable, I suppose, by taking
Yeah.
it on, but it's hard. Then you also have to go in there the next time and they expect them to be nice to you too. Yeah, so, yeah, for that.
I'm trying to do everything right here. Does anybody, if you can hear me online, have any questions or anything you want to ask? We lost.
Yeah, the only thing I-
bit, but you're back. Cynthia?
No, but thank you. This is good. I'll be there for the March 19th, but seeing 3 o'clock is sort of right in the middle of my work afternoon. I'll see you at 6.
Okay.
Lower your hand, Cynthia.
No, I don't think that's her. I think that's
Oh.
something else.
Can't wait to talk about 8,000.
That's virtual.
I really have as an outline of it, so when I send it around. It's.
Alright, so are you having trouble reactivating your presentations?
You wanna just talk to us? You could just.
How much was left?
Just 8,006, the new law.
Okay, so you're gonna send us the slides through Carol. Get those, we'll have your slides, so can you just tell us what you would tell us about that slide?
It's all changing.
Yes, statute's 104 pages.
Light reading.
Yeah, 53 sections. Luckily, for most towns, correct me if I'm wrong, Bob, but for most towns, there are only a few sections that actually apply to towns.
Do you want to come up and talk to the owls so that people
In the.
can hear you online? Here you go.
Yeah, I can,
Okay.
more knowledge about it than I am.
Just get close enough for the microphone to pick you up. It's even got little big eyes on it, so you can talk to it like it's.
Why don't you continue saying what you're saying, Leslie?
So there are only a few sections of it that apply in the fairly near future to towns. There is a requirement that the towns will have to create a housing growth management plan. That all towns in the state will have to do that. There are some decisions coming up, whether you want to go along with the regional planning agency's version of what you ought to have for affordable housing, or whether you want to create that in-house. My view is that the towns that I talk to and the towns that I work with, I'm suggesting that they create their own plans. The downside of that is it's costs money to do that, have to pay somebody to do that. You might get an inexpensive consultant, or you might get somebody who has a lot more to do, a lot more people to pay than I do. But yeah, it's a choice you need to make in the next year or so. So those are the things. There's a tremendous amount of detail in that particular statute. We have to make maps of all the land that's developable in town. People are saying, well, what's that mean? Well, land that's been reserved for open space or is currently town-owned land, which has been some specifically reserved not to be built upon, doesn't count. But there are vacant land in town that is available for development that will be on a map that the state OPM will have, and will say, well, we think that X number of units of affordable housing should go there. So that's why I think the town should control their own destiny and do their own plan rather than have the planning agency do it. But that's really up to.
And it really starts with an open space plan that we talked about earlier. A real well thought out open space plan, because vacant land is not open space land, it's vacant land. And vacant land would probably be subject to these new requirements. Not that that's a bad thing, but just understand that if it's not reserved for open space through some formal process, it's probably subject to it being designated for developable land. A lot of towns are worried about the open space land in subdivisions that's never been formally dedicated. It's just there. You know, we all have subdivisions that have been approved with 20 acres of open space, but it was just left as open space on a map somewhere, and there's no record of dedication in the land records that has a conservation easement attached to it. So that's not really open space, that's just vacant land. So. But as Hiram says, there's some time to do it thoughtfully and make decisions along the way.
And we had actually started very initially into looking at that, because we met at PNC, met with the Housing Advisory Board just last week.
Yeah.
To just start talking about this and get the ball rolling.
Yeah, and you can't slap the label open space on something. It's really got to have some functions and value as open space, you know, not livestock, but wildlife corridor, or some attribute about the land that makes it worthy of preservation in its current condition.
There's also
What is vacant land,
Land that doesn't have a building on it,
but is owned by somebody?
could be.
Yeah. There are 9 COGs, which is groups in the state that have been formed, and each one of these groups, Bethany belongs to SCROG, which stands for Southern Connecticut, exactly, Regional Council. They're all councils of governments. And as it turns out, because this is so complicated, they're all meeting to try and determine, and they're all gonna have their own affordable housing person to try and determine where space is available within their COG, where are spaces available within, and what are they going to be used for? And the towns actually have to make a decision, isn't it, by this year, as to whether or not they're going to join the region or not?
No, not quite yet. I mean, there are a lot of things that the state has to do and provide information And I think they're gonna have a very difficult time getting that together. So I suspect we probably have about a year to sort of start figuring that out. But as Steve said, you know, meeting with the affordable housing people and seeing what we're all trying to do to try to coordinate that ahead of time is really a good idea.
Yeah.
Yeah.
Forewarned is forearmed. I think if we go in at least showing we're moving down that pathway, we stand a much better chance of avoiding the hammer. And if we're just sitting here flat-footed.
Right, we do have to make the decisions, but just because you own 20 acres doesn't mean the state or the town can come in and take your 20 acres
Right.
and say, this is what we're gonna do with it. So, I mean, I don't want people to panic about that, but it's just, but a lot of people think that, you know, and that's a concern. But it's, oh, this is developable. So did you want to sell the 20 acres? And if you do, what do you want on it? And what kind of developer? And can we get a developer in who will do some affordable, which does not mean low income, it just means affordable housing with other kinds of housing. And there are some subdivision ideas that people are starting to think about, to have a combination of different kinds of housing and different kinds of, you know, maybe a duplex that looks like a single family home that might be affordable. Exactly, starter home, 1,200 square foot homes rather than 3,000 square foot homes. But, you know, do we have a developer for whom it would be worthwhile to come in and do that? So while there's vacant land, I mean, it doesn't imply that the state or the town is going to come in and take your land.
It's if it's privately owned vacant land, I think the target here is municipally owned vacant land. But
again, developable lots are still developable, but no one's gonna force you to develop it. If you then decide to sell it, one of the people coming to buy it might be one of these groups that wants to put it in. But then it's out of your hands, you know what I'm saying? Then you're just selling it to someone who wants to buy it. And they're the one who has to then put the development together. But again, if we at least if we're moving down, like you said, at least what would be nice for Bethany, when maybe there's different ways of zoning things that we can have available. So that if someone sells the land in that area, or if someone sells the land, we can use that as a model for developing in that region, so that we're not getting hit with something that is somebody else's idea of what should be in Bethany. And that's what I'm trying to avoid, is to make sure that we have a Bethany suitable plan, or at least moving towards one with enough progress rate that they're not going to go, oh, you guys are not doing anything, we're going to come in and do it for you. Because those are the people going to get hit first. The people are just sitting still and not doing anything. I mean, we're not high on the list for anyone to come in and do this anyway, because we don't have a major transit line through here. We're not on a rail line. You know, we don't have huge center of commerce that people would easily walk to get a job. So there's certain things that we have that we're not like high on the list anyway.
It appears right now that the prime areas that they're looking at, even in some of the new laws that they're trying to send out a committee, are along transit districts. And there's different monies being afforded to those areas that have transit districts. And can you put different kinds of housing in a transit district? I mean, we don't happen to have the train tracks go through here. We don't happen to have really a bus line that goes through here. So we're not a transit district, but that seems to be right now what people are looking at. Now, could that change next week? Sure, but that seems to be what everybody's talking about right now.
I mean, most of my family lives in California, and this has been going on in California for around 10 years or so. And they're moving out of just their transit district phase now. And what I'm seeing them doing is not something I want to see in Bethany. So I think if we get a good sort of framework for what we think would fit, at least that gives us some, measure to hold against people who come in with projects and go, well, can you do this instead, rather than this giant box of little cubicles? And I think that's I think what I would ask us to move towards as we go to address this.
So that's the end of my presentation. Thank you.
Yeah, so I want the slides too, so I can keep, because some of these are, I'd like the parts of 8,002, I'd like to see what you both.
Yeah, I've broken it down by section, not a lot of narrative, but at least.
And then a lot of this stuff too, because I took little sketchy notes to dovetail with your slides.
So watch, you need, Bob a while, give it to me and maybe get it out to you. So I figure a week or two, if you don't get them, call me. But we'll send it out to everybody. I have everybody on email list. Any questions, comments, thoughts? You're very kind to come. This was really, really important that everybody sort of was on the same page and we had, training. So really, thank you so much. If you want another kind of training, if you want something else, just holler, I'll accommodate.
Yeah, there's lots of available training out there. Most of it is free or close to free. And UConn has a lot of great stuff.
I'm gonna hang up the Zoom call at this point, guys. Thank you for coming.
Thank you.
Thank you. Monday.
Okay, you're
My
ready?
pleasure.
Go that way.
Yeah.
Thank you for putting this together.
Yes, thank you.
Thank you.